Hello, everyone. Welcome. I'm Chris Babel, the CEO of TrustArc. We're excited to have you here today as we talk about the role of ethical analysis in privacy and data protection assessments. So as we kick this thing off, I wanted to, before I do introductions of the esteemed speakers that we've got today, share just a hair of perspective. At TrustArc, we're working with kind of over 1,000 companies in the hot privacy topic of the moment, which is helping them solve for GDPR. And it's incredibly interesting to kind of see all different things. Things from the biggest companies in the world that do $10 billion a year in revenue to the smallest that might do 5, but really the differing levels of maturity that they might have in their privacy programs generally, specific with regard to GDPR. As we all know, a part of GDPR is a lot of things thinking about how you do privacy impact assessments, data protection impact assessments, whatever you may call them, depending on your location. And we really wanted to delve a bit deeper into them today because while you have this big and pressing guideline around GDPR that has many people who are, let's say, on the less mature side of things, worrying about what the checklist and checkbox items are that they'll try to get through by May 25th, what's great about that is that they're getting started. They're building momentum. For the more mature and sophisticated companies, a lot of the conversation we'll talk through today about taking that the next step, thinking about ethical implications, incorporating more complex thinking into what some are thinking of as checkbox items, is really the next stage of the conversation that many companies are starting to be ready for today, and I think many more will be ready for tomorrow. So to kick things off, let me introduce the group that we have with us. As moderator, we'll have Dennis Hirsch. He is the professor of law and faculty director of the program on data and governance at the Ohio State University Moritz College of Law. He's also the professor of law at Capital University Law School. Welcome, Dennis. On his left, we have Gry Hasselbalch. She's the co-founder of the think tank DataEthics.eu. She's worked as an ethics expert across a whole different variety of topics and projects like the EC Horizon 2020, the ERCA. She's also the vice chair of the IEEE Engineering Standard on Human Agency, and a recently 2016 published author in her book, Data Ethics, The New Competitive Advantage. Welcome. To her left, Evert van Veen, a longtime legal consultant, really across all sorts of areas of healthcare, with a current focus on public health. He's currently affiliated with the Dutch Association of Biomedical Research Societies, supporting Dutch Institute of Public Health, as well as many others, in its public screening programs. Welcome. Gemma Galdon Clavell, she's the director of Eticas Research and Consulting, which is a Spain-based research SME working on the legal, ethical, and social impacts of data-intensive technologies. She's also had her PhD in surveillance, policing, and policy, and has held positions at the UN Institute for Training and Research, as well as many others. Welcome. And last but not least, Hilary Wandall. She's the General Counsel, Chief Data Governance Officer, and Corporate Secretary at TrustArc. She oversees all legal, regulatory, policy, and partnership matters for the company. And prior to that, she'd been at Merck over here in Europe, known as MSD Pharmaceuticals, for 22 years as their Associate VP Compliance and Chief Privacy Officer. Welcome and thanks, everyone. Dennis, I'll turn it to you to kick us off.
Thanks, Chris. So our program today focuses on data ethics. And I think in order to think productively about that topic, we first have to ask ourselves, what is data ethics? When we talk about data ethics, what is it that we're talking about exactly? I think one thing we can say about this is what we're not talking about. We're not talking about meeting legal requirements. Meeting legal requirements is compliance. And data ethics, I think the way this term is used in the privacy and data protection field right now, generally is used to mean something different than compliance, something more than compliance. But what exactly does it mean? When I look around at people in our field who are writing, who are speaking, I see the term data ethics used in at least 6 different ways. And so let me run through them for you. One is where companies, and I'm mainly focused on the private sector here. I think of some of this also applies to public sector government use of data, but I'm going to focus on the private sector, where companies have data that they could use for the social good, and they need to decide whether they're going to do this. So for example, if you have a company that sells a fitness tracker, and they're collecting biometric information, and they find that they could predict if somebody's going to have a heart attack, they face a question: should they tell those individuals about this? This is an example I got from Michelle Demoy at CDT. Should they tell the individuals about this finding? Do they have an obligation? Do they have an ethical obligation to tell the individual about this? If they do tell them, are they invading the person's privacy? This type of ethical issue, ethical question, about whether to take steps affirmatively to promote the social good with data that you have or not is what some people mean by data ethics, resolving those types of ethical questions. Most people who use the term, though, are not talking about steps to promote the social good. They're talking about the ways that data can cause harms to individuals and about reducing those harms. So in that sense, ethical use of data is use that minimizes the harms to individuals, right, while accomplishing whatever good it achieves for the company or otherwise. So it's more about reducing harms and not hurting people than it is about actively promoting the social good, as in the first example I gave. And for these uses of the term data ethics, then the question is, where do we draw the line? You know, how much harm is too much? What does it mean to be ethical? What does it mean to be a responsible steward of your data? And how do we know? And what standards or what frameworks do we use? I think that's really kind of what data ethics primarily is getting at. And I see 5 approaches to that as I look around at the way the term is used. One is simply we look at whether the benefits of the data use outweigh the costs. If the benefits outweigh the costs, then it's ethical. If the costs outweigh the benefits, it's not ethical, viewed in social terms. And this we could think of as a utilitarian approach to data ethics, and that is how some people use the term. Others look beyond utilitarianism to other philosophical traditions, Aristotelian ethics, Kantian ethics, virtue ethics, to inform these questions about what types of data use or collection are appropriate and responsible and which ones are not, which are unethical. And so they will draw on these philosophical traditions to think about these ethical questions. And I call that the great philosopher's approach to data ethics. Still others derive the standard for what's appropriate, what's responsible, what's ethical from charters of fundamental rights or human rights. And I'm thinking here, for example, the Information Accountability Foundation, which has published a very well-known, in the States at least, framework for what constitutes ethical use of big data. They say that they are drawing their ethical standards from the UN Charter on Fundamental Rights. And so in this context, digital behavior is ethical when it complies with these fundamental human rights, and it's unethical when it doesn't. So that's another benchmark, another yardstick for distinguishing between ethical and unethical use of data. And I call this the human rights approach. Still others see data processing as a form of human subjects research. A lot of times companies are taking personal data and using it for research, and so it's a type of human subjects research. And so they look to the university setting in which there's a whole system set up for approving human subjects research before it's carried out. I don't know if you have a similar system in Europe, but in the States it's the Institutional Review Board, or IRB, and it has a set of ethical standards and frameworks that it uses to determine whether this human subjects research is going to hurt people, in which case they won't approve it, or whether it's safe, in which case they will. And so in this context, data ethics is fulfilling these principles for human subjects research. That's another meaning of what it means to be ethical in your use of personal data. Finally, some use the term to mean beyond compliance risk mitigation. Use of data can hurt people. It can invade privacy. It can cause unfairness. It can hurt people in other ways. And this, in turn, poses risks to the business that makes this use of data. If it becomes public, what they've done, that they've hurt people, it can hurt their business reputation and their brand. It can hurt their relationships with customers. It can hurt their relationships with regulators. It can keep them from achieving their own corporate values. It can hurt company morale. There's lots of risks involved for the company, in addition to, let's say, even the more important risks to the individuals, but there are risks to the company. And so, in some cases, legal compliance is not sufficient to mitigate that risk. And so companies go beyond compliance to mitigate the risk to individuals and so to themselves. And I think of that as beyond compliance risk mitigation. I think actually that's the primary way, in the States at least, that I see people talking about what data ethics is. It's going beyond what the law requires to mitigate risks to the individual and so to the company itself. And if we look at it in those terms, it's really not such a mysterious or unfamiliar concept, because we have seen this in other fields like the environmental field or worker safety or labor, going beyond what the law requires to protect the environment or protect people and so mitigate risk to the business itself. In the states where unfortunately we don't have much climate change regulation, you see it there that some companies will voluntarily reduce their carbon footprint to mitigate their reputational risk, their regulatory risk, their environmental risk. It's beyond compliance risk mitigation behavior. Another word for that I think many of us are familiar with is corporate social responsibility, CSR. And so another way of looking at data ethics is corporate social responsibility for the use of data. So I think there are at least 6 ways to think about data ethics, how we talk about data ethics: the social good, utilitarian, the great philosophers, human subjects research. Another one that I mentioned that I'm forgot, the human rights approach, and beyond compliance risk mitigation. And I hope that clarifying our use of the term, or at least identifying the different ways that the term is used, will help us to think about what it means actually to practice data ethics and to know when data ethics is being achieved and when it's not. And I hope that it will give you some insight into the very interesting presentations that you're about to hear from my fellow panelists. So I will turn it over to them.
Thank you, Dennis. So I'm going to take off where you left because I will actually build a little bit on what you're saying. I've been asked to give a little bit of social and cultural historical context to this very practical discussion about ethical impact assessments that I know is going on in a lot of businesses right now. A lot of consultancy firms are working with this right now, and a lot of organizations, in addition to this concept of privacy impact assessments of the GDPR, which is a requirement in the GDPR now. But so you build a little bit on it, Dennis. Why should a business or an organization really think about this and consider this ethical dimension of data exchanges now, right now? So some of you might know, and you were saying it, that I published a book last year that was based on some research for some years where me and my co-author, we went around, we talked to companies and policymakers, people, experts about this thing that we call the data ethical paradigm shift. So we basically mostly talked to companies that were doing things a little bit differently that what was normal practice in terms of data practices. So these businesses, mostly we found them in Europe. They were adapting their data innovation practices according to some very kind of specific ethical ideas, and I agree with you that there's different kinds of dealing with ethics and different frameworks for dealing with the efforts. These were in particular focused on human agency, the concept of privacy, data control, and so on and so forth. And one could say that the way we saw it was that some of these companies were, at that time, now it's not a new thing to be concerned with these things, but at that time they were kind of at the forefront of influencing things, but at the same time you could also see them as someone that was just responding to a general change in sentiment in society, a general change in the awareness among policymakers, among people in general. They were building on these media stories, on hacks, of mass surveillance scandals, of the loss of control of data. So as actually exactly what you were saying, you could see these data ethical consideration as a type of the way they saw it, these companies, and the way many companies are seeing it now as a type of risk mitigation. It's due diligence. It's in general just something that is considered as necessary. So this is also why now when we're talking about the GDPR, we look at it as now it's the end process and this is the law, but I think that it's much more important to look at this as a symptom of change. There's a change in society where we're starting to consider what does data mean, what is the role, how does it influence different kinds of society processes and so on and so forth. Now, in terms of, it's possible to just comply, to do just a privacy impact assessment, but why should we consider social and ethical factors also as part of this assessment? I think that we have to look at this in the sense that it's a question of an evolution in the way in which personal digital data exchanges they have increasingly become integrated in the social structures of our lives. They're not just influencing, they're not just shaping our identity, they're actually also part of this very social structure of everything from our economies to our politics and also our local communities. And I wanted to give you an example of a case that we have going on in Denmark at the moment, because I think it's a very good example of a kind of two kinds of impact assessments that you need to perform before you actually implement a system and design a system. So since 2015, we've had this thing called well-being digital tests in Danish schools. And in these tests, children are asked to answer certain questions regarding their well-being, regarding if they feel bullied, if they have friends in school. And these answers are digitally stored together with the children's national ID. They're also correlated with other types of data, for example, test performance data. And in general, the data from these tests, it's analyzed and it's used by municipalities, also by analytics companies, schools and teachers in their work with the well-being of the children. So, for example, they're used to create sociograms over who plays with who in the class and so on and so forth. And so right now there's a big debate about details of this system because generally people thought this was anonymous. When it's combined with the national ID, it's not. And of course, so as you can see, there's some pretty serious privacy impact assessment. The system has been stopped and paused now. But what I think is more important here, and which I think is really important to think about when we build these systems, this is this thing about why it's important to have ethical and social considerations. Because it's obvious that there are social risks, there's benefits and community influence built in systems like this. And they can be assessed on the basis of the very design of things, just like data access, or who has access to the data, who can use this data for what do the parents and the children know about this, how does this data analytical system influence the local communities, the schools, the actual social structure of these children. So this is a very concrete, this is why this very concrete ethics assessment is very pivotal, but I want to refer back to what actually, again, I keep repeating with you, but I thought it was a very good introduction, this thing, because it shows that there's so many ways of of considering ethics, which doesn't mean, though, that I think that you should actually be going at this. This is not a reason why you should go ethics shopping. I actually think there's something more fundamental missing before we can actually do these practical ethics assessments. And that is that, as we saw, for example, with the GDPR, there was, with the reform process, it was a heavily interest-based debate. There was interest from the industry, there was interest from civil society organizations. It was very, very much discussed compared to the other 1995 process. And this is, of course, because as we see, the role of data has changed. Everyone understands the power of data. And as you said, you know, what is ethics? Ethics is culture. It is a set of shared meanings that are produced within a given society, but at the same time, they're also represented in laws. And that, of course, means that ethics is not a given thing. So our choice of ethics is a value choice. And so when we choose a specific kind of ethics, we choose to focus on some risks, we prioritize some interest, we distribute roles and responsibilities. And that's why the first step in this ethics impact analysis is not to define specific little details, practical details. It's actually to have a societal discussion about what kind of ethics do we base our ethics assessments on. So there's a basic theory in traditional computer ethics is that when laws they don't follow pace with technological progress, then we have policy vacuums, and that's when we start revisiting cultural value systems. And this is where my kind of cultural analysis comes into the whole thing. Because right now, based on what I see, I used to look more in the business environment. At the moment, I'm looking in the policy field. But right now in Europe, as I said, I see a very kind of, I would say, positive focus in the business world and in policy making on these fundamental values regarding human dignity and freedom. Of course, they're embedded in our human rights system. But I would also say that it's a little bit more than that. It's this very human-centric ethics where technologies and information systems, they are readapted to the human by designing human agency, control, insight, data ownership into these systems of data exchanges. So we have something like the personal data store movement. It's spreading all over the world. There's the legal provisions where I would say that the whole idea about data protection by design is a value choice, and it is based on a kind of human-centric approach. And this return to this core role of humans in regards to technology happens, of course, because they're under pressure right now. And as I see it, and this is, of course, my cultural analysis of the whole thing, is that there's a clash between values. And I see it very much in many of these debates. Last year, there was a lot of focus on ethics debates here at Cpdp, because I see a competing ethics at the same time where humans, they're kind of seen as much less important in the larger scale of things. This is also a kind of ethics. You could also look at it as the universe that consists of a lot of equally privileged things and objects and people where everything has to adapt. And so we have to adapt to the evolution of technology. I, of course, think that the most important thing is that we're clear about this choice. That if we're making this choice, we need to be clear about it, or at least we need to make the choices more transparent. I, for once, would prefer the human-centric way forward. So that's kind of my...
Thanks very much for being here. And yeah, I think this topic, this works, so, is very timely. And indeed, there were also other panels which discussed ethics beyond compliance, so to say. And I'm in slightly, how would I say that, competitive advantage, if I may say so. And that is for my background in medical research and that you're all, so to say, not-for-profit researchers working at academia, working in public health. And though that might not be a guarantee for ethical behavior, and I will give an example later, nowadays it might help. And ethics also has an advantage, speaking from the medical field, as that is a famous quote by Toulmin in 1984, I think. He wrote an article, How Medicine Saved the Life of Ethics, because ethics was more or less a dying kind of activity, and the challenges by medicine sort of revived ethics. So we have a tradition in ethical thinking at the moment. Then I will go to my text, because otherwise I might get lost, if you pardon me. The other way around worked as well, and that's why I say that now ethics, so to say, is sort of on the forefront of medicine and research. You might even say that, ethics saved medicine and medical research, because there are so many, so to say, very intricate and also worrying examples and progress of medical research, that without being embedded in an ethical debate, we should be very worried. And that ethical debate now is called the ELSI debate, the ethical, legal, social impact of research. The term was coined by Watson in somewhere three decades ago, when he was had moved to the US to start with his genomic research, and he wanted to have a sort of counterbalance, and that was then the ELSI discussion, and also ELSI funding. And nowadays you cannot have a research project without also having an ELSI paragraph in it and looking at it from the ELSI perspective. It hasn't been always the case, by the way. And now we know, of course, of the Nazi experiments. That might not have been called medicine, that might have not been called research either. It gave rise to the human rights instruments after the war. It also gave rise to ethical codes. But even in countries where there was sort of a normal social system, though with racist undertones, if I may say so. In the US, the Public Health Authority started an experiment to follow the national course of syphilis in 1933, that was, and in an impoverished community of black people in the south of America. Without telling them what they were doing and why they were doing, only telling them that they would get free healthcare if they gave their blood. Well, that was not very ethical, but what became much worse was that in 1947, the penicillin had been sort of the standard of care for syphilis. They didn't get it. They continued to take blood samples, and only after a public outcry in 1970 somewhere, the experiment was caused to a halt. There had been sort of opposition from within the medical community before that, but that was shoved under the carpet. There had to be a public outcry. After that, there came a lot of regulation in the US, which we'll delve into. But now the standard for participating in clinical trials, whether it is in the US or here in Europe, is that there's sort of a two-tiered ethical assessment. The first is by an institutional review board, like you mentioned, Dennis, or we call it then an medical ethical committee here in Europe, which assesses whether the experiment is by itself sufficiently balanced on the risk for the participants against the possible benefits, either for the participants or for medicine, because some experiments don't have any benefits for the participant himself or herself. And then there's a second tier, which is the informed consent of the participant himself, whether he, on the balance of all things, his values, his expectations, etc., decides to can make an informed decision whether or not to participate in the trial. So that is two-tiered approach. And so that is informed consent before you participate in a trial. Well, now, informed consent, that might ring a bell in the GDPR discussion, because informed consent is one of the legal bases for processing personal data. But there's a difference, because informed consent is one of the legal bases, while for participating in a clinical trial, it's the only legal basis. And there is a reason for that, because doing research with data, with health data, is very different from participating in a clinical trial. It has less dangers for the participant, might not even have any dangers at all. Well, we might discuss that later. And it has also a very much different sort of risk-benefit, also benefit for society. Well, that was a long time discussion in getting to the GDPR as well, because the European Parliament insisted very much on informed consent before data would be released for research, and left a very, very narrow escape. And so there was author Graham Laurie who said, about 5 years ago that they were very much trapped in the consent or anonymized dichotomy, and were also very much sort of captured by that, was their words, by the way, not mine, fetishification of consent. Well, on the other hand, there might be also a harm not to reuse health data. That was another publication which is very interesting, which came out last year. Harm because we leave people sometimes, without a proper treatment or without proper health protection if we don't use those data. Now we come back to the and so the final version of the GDPR brought back a balance thanks to the influence of the Council. At the expense, by the way, of not complete harmonization, because that will, so the exemptions for consent will be very much fine-tuned by the regulations of the legislation of the member states. That being said, what now is left over of the second tier? Well, not very much, and there are very influences which contribute to that. For example, we use a lot of data in health research. Those data need to be fair, which means findable, accessible, interoperable, and reusable, which means that actually you can never predict fully where those data will end. You also can never fully predict for what sub-studies these data will be used. So there is a sort of, even if there is consent, can be consent, there will be a sort of that can only be broad and not very fully informed. There is another thing, that with the advent of big data, informed consent is even less feasible. And then we have the rise of personalized medicine, which means that treatment will be very, very much specified for the person concerned. A drug might not work for a general class of patients which seem to have the same disease, like bladder cancer, but that might work very specifically for a subset of those diseases which have a certain genomic trait for which this drug for this type of bladder cancer will work. So that is a kind of personalized medicine which can only work with a sort of very intricate intertwining of giving medicine, healthcare, and research. Now, does this mean that everything goes? No. So the first tier, the second tier is not there anymore in many cases. The first tier, namely whether the project is, or the sub-project is acceptable, will always remain there. And that is then, how are we doing that? Well, a DPIA might be a way to do that, but it will be always an expanded DPIA. First of all, I must say something that DPIA is embedded in the whole governance of research, should be embedded in the governance of research. The governance of research means that it is transparent, that it is accountable, that it upholds in research integrity, and that it is also in liaison with patient organizations that are very now, again, ELSI projects, which try to find best practices for this governance of research, which is sort of self-governance, it's co-governance, whatever you call it, but it's not governance by government. It is how research try to be govern itself in a responsible way. The DPA then, we have the guidelines of the Article 29 Working Party of last year. This DPIA will be very much more expanded. First of all, next to the classical thing, the risk, why do you do it and what are the risks, etc. You must also consider, what if we don't do it? What harm will we do by not using those data? We must also expand the analysis to not people whose data are being used, but also to others who might profit from the data, but also it might be the case that these results of research can be translated in unfair or even discriminatory practices. Against that, it is an debate, because against that you must balance, yeah, but we might have, without knowing that, these unfair or discriminatory practices already now, because certain patients won't get the treatment which they deserve, or certain citizens don't get the healthcare protection which they deserve, simply because we don't know it, and research might reveal that. So this sounds very, well, like you mentioned, utilitarian, but I don't think it's only utilitarian. It might also be seen in the context of, and that's a little advantage then of Europe, I think, against the background of solidarity-based healthcare systems, where whatever is, if there is enough solidarity, and might there not be a little bit more or less, and co-payments and discussions like that, there is at least an equal right to decent healthcare for everybody, but we also want to have that healthcare sustainable on the longer run. And do so against that background, you might also plead for a sort of privacy in context that those health data can also be reused to improve healthcare. That being said, so there is a sort of, it is not corporate social responsibility, but it is research social responsibility as a starting point. I think that we also would need corporate responsibility, by the way, in the social responsibility on the longer run, because healthcare is getting so complicated nowadays with that personal medicine that it's very difficult to, a simple decision tree, a simple consensus document that if it's this and that and so, then you give this patient that drug, is hardly possible anymore. So there will be more complicated algorithm being used to fill in all the patient data, to find the proposal, because it is of course always the patients who decide whether he will take it or not, the proposal, that is really informed consent before you get being treated for the right treatment. And it might be that we also use not happening very much yet, but we also might use then the algorithms, or at least the decision algorithms, which are now being developed by large companies like Google and IBM. And we don't want to be trapped then in what we are now trapped with pharma, namely that these little specialized drugs cost a fortune. Prices are skyrocketing because they see that it works for a small class of patients, and then they drive up the price. But we don't want that. We don't want that dependence if we are using IBM or what and Google with data which develop algorithms which have been developed actually by the input of data which were gathered in the public domain and to publicly refunded research. So there, I would like to end there. We both have the responsibility of the researchers, and we need the responsibility also of corporations to treat this data fair.
Thank you. Hi. Thank you, Dennis, for the introduction. Like the previous speaker, I'd like to talk about ethics in a particular setting. In the last few years, I've been working on the social impact of data-intensive technology in lots of different fields, but I think there's no other field that is more telling than smart borders. And probably because you haven't thought about ethics in the context of borders, because it's not an issue that it's much discussed. in case you don't know what smart borders are, it's the process of automation of border crossing. You may have seen that these days to enter or leave the Schengen area, you don't go through a border guard anymore. You don't show your document to a human being, but you use a machine, what it's called an ABC gate, an automated border control gate that checks your document, your face biometrics, and your fingerprints, and identifies you, and comes to a decision as to whether you should be able to cross that border. Europe has been implementing this automation for several years. The final legal documents are still being discussed. There was a final, what looks like a final draft that was published last April, but it's been quite controversial. This system, what it's introduced is the registered traveler program and the entry-exit system. So it means that crossing the border has fundamentally changed, and I'll get to that in a bit. And I was lucky enough to be able to start working with the European Commission and some of the industry that is developing the software and the hardware for these ABC gates back in 2011, when no one really thought about ethics in that context. But in 2010, you may remember, we had the issue with the full body scanners, which I think is one of the first times that society as a whole realized that there were some things going on with our data that were not on. The outcry against full body scanners meant that they were never deployed as they were envisaged in 2010. So in 2011, it was a good time for an organization like ours to get involved in something like this, because both the Commission and the industry realized that unless they tackled ethics and acceptability issues, they may end up with a failed business model. And full body scanners were clearly a failed business model because the companies never sold the amount of full body scanners that they wanted to, because people did not accept that technology. So in 2011, we started working with the industry and the Commission, and we've been at it ever since. So we, in a way, our PIA has been quite unorthodox, because we've been able to work with them over time and from different perspectives, because we started with the Commission and the industry, but then we also worked with the EU Fundamental Rights Agency on assessing smart border deployment from a different angle. So in the end, in the process of these 5-6 years, we've been able to gather a lot of data on the whole process and to very much assess what is the social impact of these developments. And so we started by doing what you would do, what a normal PIA would do, which is let's check the legal documents, let's see what they want to do, let's talk to the stakeholders. And we found some interesting things out. For instance, we found that first there was no legal basis for smart borders. Basically, Schengen did not allow for the automation of border crossing. But no one picked that up, because smart borders were seen as a technical amendment, not a policy debate, because it was not about changing Schengen. It's like changing, for the industry and for some people in policy, moving from human border guards to automation, it was like changing a blue chair for a red chair. That's it. It's like, it's the same process. It's just a bit different, but it's exactly the same. And what we found is that that is not the case. And so no one went back to Schengen because no one realized maybe there's something that does not allow us to do that. And what we found was that the Schengen Border Code said that you cannot systematically do background checks on EU nationals. If you automate border crossing, anything that you do is systematic, even if it's random. It's systematically random. So we had a problem there, and that's something that has been addressed in newer text, because we realized that you could not keep on pushing smart borders as technical amendments. This deserved a policy debate as to what was happening. So we found this, which is a fairly simple thing to do, read the legal framework, see what issues come up there. We also found that talking to the developers, they had no idea what the limits may be. So one of the initial debates that we had is that the industry was saying, we're going to fingerprint the 10 fingerprints. And we're like, well, we checked the literature, and we were like, actually what the literature says is that in terms of security, there's not much difference between fingerprinting two fingers or 10. So in terms of data minimization, you may want to record only 2. And we won that debate. But it was amazing that the people buying the technology, the public bodies buying the technology, were not letting the providers know what the limits may be or the things that they had to take into account to develop that technology. And I think that these are things that can be picked up on a regular PIA. Then we were able to also follow the process on the field. So we've been able to oversee how the deployment has been happening. And then what we found, of course, that there's no information on data protection. Like these days, you go through an ABC gate and you have no idea what's happening with your data. You don't know if your biometrics stay in the machine, whether you're only being identified, whether you actually, your identity is being checked against databases. You have no information. And so we also highlighted this as an issue that had to be taken into account. Talking to users and border guards, we also found an interesting mix of trust and distrust by these two collectives. Users tend to trust the machine more unless something goes wrong, because we don't have any redress mechanisms. And in this case, we could have learned from the US, because they've had automated borders for a lot longer, and they realized that they didn't have a redress mechanism, and so they created it. We're failing to learn from those that are ahead of us, and so we're implementing smart borders in Europe without a redress mechanisms. And so that's one of the things that we are recommending that is done as soon as possible. But we've also found that border guards are uneasy with this new technology, because they feel that they've gone from being these intelligence personnel to being queue managers. Like before, they had to assess whether you could pose a threat. And now they're just like telling you to go through the machine. So there's also issues of how do you relate with these frontline operators? How do you make sure they understand the process? How do you make sure that they can reproduce it? They're the frontline people. They need to talk to the users. How do you make sure they also trust the system? How do you work with them? And we found that that's also something that is missing, the issue of training and awareness of frontline operators. It's missing across the board, I would say, but we also find that missing in the smart border deployment. And so again, these are some of the recommendations that we've been putting on the table for before the Commission and Frontex, the different agencies and bodies that we've worked with in the last few years. And again, these are things that fairly simple that you could find in a PIA that I think are already indicative enough of how useful this process is in terms of seeing things that could cause problems, even in terms of risk analysis and avoiding costs down the line. But we've also found a lot of other things that no one's thinking about. And I think that's what speaks for the need to go way beyond a checkbox exercise, PIA, check the legal framework, and that's it. We found, for instance, that through automation, and remember, this was initially a process like changing a chair of one color for another chair. It's nothing massive changes. Actually, we have changed the nature of borders. Through automation, through this thing that no one should pay much attention to, borders have stopped being a line on the sand, which is what they always were. Before, you were accepted in a country when you got to that line, or an airport if you were flying. But the physicality of the border has always been extremely important. Through automation, the physicality of the border has completely disappeared. Going through the borders these days, it's a checking procedure. Your vetting has happened a lot before. Automation doesn't happen at the border anymore. Automation of whether you should be able to cross the border, vetting of your rights to cross that border happens when you buy your plane ticket, because through the Registered Travelers Program, this information goes to the authorities, or when you apply for a visa. So it is then that you are crossing the border. So when you go through the actual border, that doesn't really matter. You remember if you've gone to the US recently, going to the US 5 years ago, the queues to enter the country were massive. Today, it's 10 minutes, because it doesn't matter anymore. All the important stuff happened before. So the physicality of the border has completely disappeared. But not only that, the border follows you wherever you are, because with the entry-exit system, if you have a visa, they make sure that you can be identified wherever you are, and when your visa expires and you haven't left the country, an alarm goes off, and then the police actively search for you. So again, the border has become this process that comes with you wherever you are. So through, again, a technical amendment, we've massively changed the nature of what borders are. We've also changed the relationship between travelers, especially migrants, and their bodies through the introduction of biometrics. In the past, if you wanted to hide your identity, you would burn your passport. That was what said who you were. If you wanted to hide that, get rid of that document. When your identity is ingrained in your body, what happens? Well, we're beginning to see migrants mutilating themselves to make sure that their identities cannot be revealed. That we could have foreseen that. We knew that was going to happen. And now we're just finding it happening and fundamentally affecting fundamental rights. And we don't really have a solution because we've made identity part of our bodies. We're also changing the definition of citizenship. When you go to an airport, there's usually two lines, Schengen nationals, non-Schengen nationals. That's not a random decision. It's not queue management. It's because your rights at the border are different, whether you are a national or a non-national. Basically, in our legal systems, it's not very nice to say it, but that's the way it is. If you're a national, you have all the rights. If you're not a national, you have no rights. That's the way it is. With this process, what we find is that we have no way to control whether the machine is respecting this, whether the databases that are being checked according to our legal status. What our definition of citizenship says is that as a citizen, you always have the right to enter your space of sovereignty and fall under the laws of that space of sovereignty. You have a right to not be suspected upon when you're entering your space of sovereignty. These days, we don't know if we're being suspected upon when we enter the Schengen area being EU nationals. We have no way of knowing. And actually what we're finding is that there's more and more systematic suspicion of anyone who tries to enter or leave Schengen. So their fundamental definition and protection of national beings, of citizens, has completely changed. The basis of our constitutions for the last 200 years has changed through a technical amendment, which, as you can see, is way more than a technical amendment. We're also seeing other things. We had, in our field work, we had to go to the Global South to see how the vetting process was happening at the beginning of this process, how embassies were processing fingerprints and how they were deciding whether migrants could come, what qualitative impact biometric fingerprinting was having on the decisions that were being taken. And we had a really interesting conversation with an ambassador in an Asian country that was saying that one of the things that worried him was that with the new biometric process, because biometric fingerprinting is being outsourced to private companies that have their own venues to do this. So it doesn't happen, oftentimes, or less and less, it doesn't happen at the embassy, it happens somewhere else. So embassies don't need to have that much space. And at a time of massive cuts in the public sector, many countries are choosing to relocate their embassies to small offices in tall buildings, or they may be on the 54th floor of a mall somewhere in Bangkok. That's what we found. And this ambassador was saying, this ambassador was still part of a large embassy compound and was saying the role of the embassies is not only to approve people going to the Schengen area, it's also to protect people. And the role that physical embassies have played in the past in protecting people by allowing them to physically enter that space and provide that protection completely disappears when your embassy becomes this small office in the top floor of a commercial building. So there's all these things that are happening linked to, again, I think what's supposed to be a technical amendment, which is fascinating to look at, but also incredibly worrying. And it's clear that someone should be deciding whether, as a society, this is a positive step, whether we want to use this system that has all these implications, and whether we want to mitigate the impact of these implications. And it doesn't look like there's anyone thinking about these things. So one of the things that we've learned through working with borders, but also in lots of other fields, is that a PIA is oftentimes very limited, but it doesn't have to be. You can be looking at all those things when you do a PIA. You can make sure that when you do a PIA, you not only look at legal compliance, but you look at desirability. You ask, are you actually solving a problem, or are you just another technology in search of a fake problem that you want to solve because you want to sell that new gadget? Because if that's the case, maybe you don't even need to do the PIA, because what you're proposing clearly falls out of any definition of what we think is socially acceptable, especially when fundamental rights are involved. Make sure you look at acceptability. Do people understand and trust your system? Have they been part of your decision-making process as to how to create the hardware, the software, and the procedures? Look at ethics, but not only the legal codes. Look also at trust. Look at social cohesion. All these values that we have ways to measure them, so we can see whether a new technology is impacting positively or negatively on all these effects. You can make that part of the PIA. And finally, look at data management. Make sure you audit those systems, because you can have any provider come and tell you, don't worry, my ABC system doesn't check your data against any database. But unless you can actually make sure that is the case, you should not believe that. Companies and providers should have the obligation to prove what their data management procedures are, and we should not be left in the dark or just led to believe their words. We should be able to audit those systems, especially those that buy it. Basically, if a country is buying an ABC system, they should be able to know what the ABC Gate is doing with nationals and non-nationals. So that's what we've built in our PIA. We don't call it PIA, we call it data impact assessment, but we make sure that the legal compliance is only one more step in this broader understanding of the risks that emerge. And having risks emerge with your technology is not a problem, as long as you know them and as long as you mitigate them. So don't be scared by that. Don't be scared by the ability of a PIA or a DIA to bring to the fore all these issues, because there's things, I'm finishing, there's things that you can do to make it much, much better, but you will only know what to do if you go through the process of thinking through the implications of the technology that you're building. Thank you.
Well, thank you, Gemma, for such a wonderful example. I mean, very, very compelling example of how these ethical issues are applied in reality, in practice, and how that affects the way in which governments, societies, think about privacy and data protection as really being a strategic factor in their decision-making process. And particularly for me, one of the reasons I'm excited and really delighted to be part of this panel today, so thank you to the organizers and certainly to the rest of the panel for allowing me to join you. I'm really very interested in how this particular aspect of ethics helps, is done in practice, first of all, but how, when it's done effectively in practice, it makes the notion of privacy and data protection far beyond the check-the-box exercise that many of the panelists have been discussing, and much more a part of how organizations, how governments, how various different bodies, companies, et cetera, whether they're for-profit or non-profit, are thinking about privacy and data protection issues in a way that is more strategic and a fundamental part of the way in which they operate. And that's particularly been important to me over the many years in which I've been dealing with these issues. From an ethics perspective, I'll go all the way back to more than 15 years ago. One of the early issues I was confronted with was a question about whether or not genetic samples that we in my former company had collected could be used for some future research. And as many of us know, and it was a biological sample from which genetic data could be extracted. And as many of you know, for many, many years, people considered tissue samples to be able to be used as long as they weren't tied to specific identifiers. Those were able to be used for additional research to better understand ways in which scientific problems could be solved and to find new cures, many of the kinds of things that Evert Ben already talked about. And in the context of that scenario that I was confronted with over 15 years ago, we didn't know the answer. And we didn't know the answer in part because the informed consent form that Evert Ben talked about didn't say anything in that regard. And what we knew is that the ability to begin to identify individuals from their very genetic data, from their bodies themselves, was beginning to change. And so at that point in time, we started thinking about, to the point that Dennis made earlier, the fact that mere compliance, following what the consent form says, is not enough. We needed to think beyond that, and we needed to take other aspects into consideration. And so for us, what we decided to do is actually put in place an ethical review committee that was not your traditional institutional review board or ethics committee, but was rather some of what we're hearing now in the data ethics context, individuals who come from different places, are not necessarily inside of the company. Certainly there's inside company representation, but you have other external stakeholders coming in and looking at whether or not this is an appropriate decision and factoring in various different contexts from different frames of reference. And so from that point on, in my role as a privacy officer, it became important to me to think about how ethical issues can be addressed in practice. And going back to the very beginning of what Chris said when he kicked us off, where we so much right now are thinking about, and so many organizations are thinking about preparation for GDPR. We have this May 25th deadline looming. Preparation for GDPR, so many organizations are looking at what boxes do I need to check to make sure that I've appointed my DPO, that I have a policy in place, that I have individual rights mechanisms in place, that I have a DPIA or PIA process in place, that I can handle security breaches. But they're not necessarily thinking through these bigger issues that actually will affect whether the decisions that organizations make post May 25th, so on May 26th and thereafter, whether or not those are the right decisions that the very language of GDPR was designed to address. As I'm sure most in this room are well aware, prior to the GDPR, the notion of fundamental rights and freedoms was certainly embodied in prior legislation and in the directive, but not in the way where it was specifically tied to risks. And so we know now in the very legislation, both in the recitals as well as in the way that the various different articles of GDPR are written, that risk to the fundamental rights and freedoms of individuals is a critical goal of GDPR itself. But how is that addressed? And so what I want to talk about in the remaining few minutes that I have before we go to a Q&A is to talk a little bit more about how practically we're trying to think about enabling organizations who are really very focused on moving forward and still at the point of checking boxes to begin to use the tools and the mechanisms that are available in the very structure of GDPR itself as a basis for introducing ethical concepts. So what do I mean by that? I'll start with the idea that we talked about earlier of corporate social responsibility. There is a requirement under GDPR that when you're engaging with data processors, but you can extend that to any other party with whom you engage, to really make sure that you know whether they can uphold the responsibilities for data protection. Many times we think about that strictly as requiring written agreements. But I would go so far as to say that what organizations are beginning to do, and what we're seeing happen more and more, is a process by which what has been strictly security assessments of vendors is turning more into a privacy, data protection, and data security impact assessment of the organizations with whom you're doing business. This is important, as many of the other panelists were talking about outsourcing to third parties. I think Gemma just mentioned it in her remarks. And in that context, there's a lot of different things that can be assessed. Certainly you can assess the specific practices of that vendor as it relates to what they're doing for you. But I would purport that even more importantly and before that is a question of whether that third party has the right kind of structure in place to be able to support you in terms of not just saying yes in writing will do it, but whether if things become more challenging, if disputes arise, whether they're going to be the kind of partner that actually can support you in a way that will be appropriate given the risks to the fundamental rights and freedoms of individuals and the kinds of real risks that you will face as an organization. Some of the things that I've seen over the years, and we're seeing more recently that companies are starting to focus on, is this requirement under, in particular, Article 5.2 of GDPR, as well as under Article 24, this notion of being able to demonstrate accountability, and as a data controller, or then as a data processor under Article 28, being able to demonstrate that you've got the right practices in place. And what does that mean? Does it just mean you have a policy? I would go so far as to say, from more of a ethics perspective, as we've been talking about, it's looking more at whether or not that company has the kind of governance in place, the kind of accountability mechanisms in place, not just a check-the-box appointing of a DPO, but a governance structure that's very consistent with the requirements of supporting that DPO as articulated under the GDPR. Whether that organization talks about privacy and data protection in its corporate social responsibility reporting or other transparency reporting that it does. if it does that. Some organizations don't. They're certainly not required to in every single type of company. It's usually more the publicly facing companies that are required to do things like that. But most organizations do have a code of conduct. And what do they say about their data practices in their code of conduct? Is that a value that they espouse there? Those are some of the programmatic level things that we are starting to see organizations address in a program level or a vendor level assessment. But turning more to the kinds of things that our panelists have already talked about, so DPIAs, PIAs. DPIAs, we know, are a new construct required specifically called that under GDPR. And we know that in many cases people talk about, well, they're similar to a PIA or a PIA. And I think if PIAs have been done well, as Gemma talked about, certainly if it's done in the way that Gemma talked about, you're taking into consideration the risks and the benefits and all the things that really make that decision making a part of a consultation with the stakeholders who are affected and a strategic decision at the highest level of those who are involved in the decision making process. But we oftentimes see that organizations really just have been focused on their compliance controls. The thing that a DPIA does that a traditional PIA has not always been able to do is that it forces the organization, based on going back to this concept we talked about earlier, of risk to the fundamental rights and freedoms, to go and actually look at whether the activity itself, the processing itself, is of high risk to the rights and freedoms of individuals. I know in the very beginning when the GDPR text was released, so many of us were sitting around and saying, well, what on earth does that mean? And many of us sat and started trying to define what certain types of factors could be taken in consideration to assess risk to individuals, as well as potentially some benefits to individuals, and I'll come back to that in just a moment. But on the risk side, we've been very benefited by the fact that, I think Evert Ben pointed this out, the fact that the Article 29 Working Party has come out in WP 248 specifically pointing out 9 criteria for identifying high-risk processing. And it's that identifying whether or not the processing is subject to or within the scope of those 9 criteria that gets at helping organizations begin to think about, are the controls and the safeguards that I'm putting in place actually relevant to mitigating that specific risk? Because it's only then that a DPIA, as it's envisioned under the GDPR, is really an effective DPIA. And that's, again, the kind of PIA that Gemma's been talking about, but it now actually is prescribed in the GDPR itself that it be done that way. I'm going to turn to one last form of practical construct that we're starting to think about now that takes into consideration not just the risk piece of an ethical analysis, but going back to what our other panelists have talked about already, the benefit side of things. We know, particularly when we're looking at a utilitarian construct, as Dennis mentioned earlier, the notion of beneficence, that you do need to think about benefits to individuals and societies. And one of the things I think has been very helpful to us in the data protection space over the last 3+ years has been the Article 29 Working Party's guidance around legitimate interest assessments. Now that's done under the directive as the directive as it existed as of 1995, but we think that likely will extend more and obviously will be updated under GDPR. The benefit for us there in looking at that construct is it helps guide us through thinking about what particular benefits need to be taken into consideration alongside the impacts, i.e. the risks to individuals. And we're starting to see that it's helpful to be able to look at, before you even move forward with whether it's acceptable to do any kind of processing activity, whether or not the interests of the organization, the beneficial impact to the organization that may be the data controller that wants to conduct that, is actually tied back to the purpose of processing. If there's not some benefit that they're going to get out of it, then why are they doing it at all? And so that's a first consideration that really helps make this a more well thought out strategic analysis that happens in an organization. The next piece then comes to, are there any other interests? Are there interests to society in terms of preventing discrimination from happening and other things? Are there interests and benefits to the actual individuals themselves whose data are being processed? It's only then when you've begun to look at those combination of benefits or beneficial impacts that then you turn to the risk analysis and the impacts that perhaps are adverse, going back to Dennis's first aspect of ethical analysis, to whether or not there's something potentially that we're missing that could be of benefit to individuals if we don't do that particular processing. And so it's a legitimate interest analysis coupled with how organizations are beginning to think about data protection impact assessments that really will, I think, in practice begin to transform the way in which organizations don't just check the box in terms of compliance, but actually are doing so in a strategic way.
Thank you, Hilary, and thanks to the panel as a whole. I know that the room is needed in 5 minutes for the next panel, so I don't think we're going to have time for Q&A, but I do think our panelists will stay for a few minutes, yes, if people have individual questions for you. So I'm going to ask our chair to kind of sum up and close things out for us here after these very interesting presentations.
So wow, as we think about companies that are faced with this challenge initially around GDPR, and some of them have not ever done a PIA or DPIA before, certainly there is a hefty amount of box checking going on, but as you listen to the groups and hear kind of in different industries in different areas, in particular the cross-border one, which I wasn't in full awareness of all the details going into it, but I knew it was going to be great, I think really gives you a huge sense of how these types of tools can be used strategically to think through incredibly complex issues and decisions that are being made. And I think it also points to maybe a whole separate and different part of this, which is that this process of thinking through becoming compliant but really extending and thinking through kind of benefits to society in a legitimate interest balancing test, thinking through what you're doing, how you're using data, is really kind of on a never-ending cycle. If people know me from the past, they know that I spent 15 years almost in the security side of things, and that is, I think, a helpful path for a lot of us in privacy to think about, where the threats are kind of always there. The threats to do wrong with data, with information by the consumer, with a business partner, what have you, they're kind of never-ending as well. And there will be new challenges that come out, new ways of thinking about data, new types of data, new ways to grab data that businesses will find, but also new ways that we need to think through the use of that data, how to balance interests across the board. And this is really, truly a never-ending challenge that certainly doesn't kind of stop on May 25th, if that's your first goal, but I don't think it really kind of ever stops. So with that, I think we'll have 5 minutes to grab us maybe individually for questions rather than get the one in that everyone might have to listen to. We're all available. Feel free to come up and grab whichever panelist. But thank you very much, and please thank the group up here for giving us a ton of interesting things to think about. Thank you very much.